Good morning. Hope everyone was able to enjoy the amazing weekend we just had. All right, so we have 4 cases on the docket this morning, and today is Monday, April 15. 2 of the cases are scheduled to argue. 3 of the cases are scheduled to argue. 1 has submitted on the brief. So starting with the first case is case number C230469, Frank West versus City of Cincinnati et al. If attorneys can identify themselves and their readiness to proceed.
Scott Neiman on behalf of the city.
John O'Shea and Lois Sugar on behalf of the appellate.
Thank you. Next case we have is C230492, City of Cincinnati et al. Versus State of Ohio.
Shuko Paul on behalf of the city.
Okay.
Elliot Geyser on behalf of the state of Ohio.
And I understand you put in an entry of appearance of recently,
That's
right?
correct,
Okay,
yes.
no worries. After these 2 cases, we'll be taking a brief recess, and then the docket will continue. And so the third case we have is case number C230373, State of Ohio versus Kevin Johnson.
Patrick Blackminster Johnson.
Good morning.
Should have stayed, Your Honor.
Good morning. Good morning. And the last case we have has submitted on the briefs, which is case number C240050, In Re ZF, MF, and RM. Attorney Heenan, yes.
Good morning, may it please the court, Scott Heenan on behalf of the city. Procedurally, this case is a nightmare.
Before you start, would you like to reserve time?
Oh, yes, I am the appellant. Sure, 5 minutes, please.
5 minutes. Okay, wonderful. Whenever you're ready is fine.
Procedurally, this case is a bit of a nightmare. It shouldn't have been. It didn't need to be, because if things had been done right, it would have all started in the criminal case, which is eventually where things did end up going, and where Mr. West received his adequate remedy at law, the adequate remedy he had the whole time. Instead, about 100 days after the incident that happened below that led to his criminal case, he went running to equity. Equity courts are not supposed to interfere with criminal cases. If they did, criminal courts would, we can't have every defendant running to equity every time they think some statute or ordinance.
Mr. Heenan, you filed the supplemental authority notice that indicated the dispositions of the criminal case.
I
And
did.
so there was no, I didn't see any sort of accompanying motion to dismiss for mootness grounds or anything similar, but is it your position that this dispute is moot, that there is standing? What
may
is
be-
the city's position here?
It may be moot from Mr. West's point of view, but from the city's point of view, there is a lower court
He's
order.
the plaintiff.
He is below, but what happened below is the judge granted a permanent injunction enjoining an entire chapter of the city's municipal code. And
I understand all that.
And if-
My specific question is, do you believe that this dispute is moot at this point in time?
from the city's point of view, no.
Okay, and why not?
No, because again, if you were to find that this appeal is moot and dismiss it just flat out, then your stay is going to be lifted and an entire chapter of the city's municipal code is going to be enjoined. We won't be able to enforce an entire chapter of our municipal code when even if Mr. West and Judge Marsh below were correct that there was a problem with the city's law, then the solution, which we would have gotten to had we actually been given notice of a permanent injunction and been at that type of a hearing, would have been to
Yeah, but I mean, you say that, but like, what is, on that procedural point, like, is there a proffer that you all made that said that like, oh, we would have gotten all this evidence in had we only known that this was going to be a permanent injunction hearing? Like, I didn't see anything like that.
We never had that chance.
I mean, you always have a chance to make a proffer if a trial court judge does something that you disagree with.
If the city had known that she was going to go from where we walked in thinking that we were there on a motion to dismiss and for a temporary and preliminary injunction, if I had known that she was then going to instead catch us all off guard, I mean, even when they were arguing the preliminary injunction standard, not the permanent injunction standard. if the city had known that this was going to be a permanent injunction, we would have had evidence ready.
What evidence would you have had?
We would have had, well, there was the transcript that I offered to introduce, or I would have represented the live testimony that we presented in Judge Branch's case, which is the second case you're going to be hearing this morning. We could have then, if we would have been told, hey, there's a substantial likelihood that they're going to be successful, we would have been prepared to argue what the proper remedy would be, and that would have been severance of, if there was a problem, the subsection B, not an
That's
entire
legal
chapter.
arguments.
Hmm?
That's legal arguments.
That would have been a legal argument, but the thing is, we would have been able to introduce evidence from members of city council, like we did in the state case, about what the intent and purpose behind these laws were, and that these are things that the court could have and should have considered at that point, but did not.
So you're saying that that the court should, to me, it sounds like the court realized that this was just a legal issue that it had to analyze. There weren't any facts that it really needed to look at. It just was interpreting the laws.
That may have been how the court saw it. That's not how I saw it. And again, that this is something where we would have, instead of just been presenting legal argument to me, saying this is not how this ordinance works, would have brought in people to testify about this is not how this ordinance works. This is how we're actually applying it. And here's somebody from city council who actually was part of enacting this ordinance. Here's their testimony to help explain that. There are things that we would have introduced that we were
Attorney
denied the
Hayden,
opportunity to
if I
do.
understood the onset of your response to mootness, is that basically it's not moot because the injunction stands,
Correct.
right? So I understand that you're also responding to the evidence, but it seems to me that that's really your
At this-
strongest argument.
At this point, if this were to go back down, I no longer believe that Mr. West would have standing to bring this case. Quite honestly, I don't think he did in the first place, because again, he should not have been able to take his criminal case into equity, which is what he did. And the Supreme Court has repeatedly said that there's
And I
one
understand
exception.
that position. I think the question for me is, how do you get away from the language in Section B?
When you look at Section B, what the city has done is codified what courts have said a substantial risk is, and then said, but unlike state law, if you engage voluntarily in safe storage practices, you've got a defense. And as far as the city's code is concerned, we've got no beef with you. That's what makes this different. That's what the city was trying to do with this, is it realized that under 968 it could not mandate or require people to engage in safe storage. It wanted to encourage. So it found a way to create a carrot versus a stick. And that is what that ordinance is designed and intended to do. Now, if legally, if this court or any other court were to say, you know what, no, I don't think that's what you really did, then the proper remedy would not be to enjoin the definitions in 915, the section that involves domestic violence. It would have been to laser in on that subsection B and said, here's the problem, get rid of it. And when you look at the Geiger test that the Supreme Court's put forth on whether things can be severed, that would be stuff that could have and should have been argued below and would have been argued at a permanent injunction hearing. And we would have introduced evidence about that to show, because under Geiger, one of the elements is it goes to the intention of the legislative body that enacted it.
So
It would
can
have
you,
had-
so if A survives, and B and C were stricken under, and they prevailed on that, like, what is the consequence for the city, given that A seems to be pretty close to the state statute?
The consequence would be that we would, I guess we would have to look at why subsection B, why court said subsection B was bad, and whether or not we wanted to rewrite that to make it okay. But ultimately, at the end of the day, there's nothing wrong with it. Even the Attorney General, when in the City v. State case, argued that we didn't have standing to bring the City v. State case because none of our laws were in conflict with state law. They said everything in the City Municipal Code, 968, all in harmony. You shouldn't even be here. You don't have standing for any of this.
So the trial court is interpreted to be the city telling people that they had to store safely their weapons.
From what I could make from the entry, yes. Yes, that is, that the court felt that somehow telling people that they could do this, that, I know that Mr. West argued somehow we created strict liability because we include the word shall in the one thing, but, ultimately, end of the day, the court found it violated 968 by somehow regulating firearms. And all we regulated was if you don't endanger children. And if you do in this way, you get an out if you use safe storage. And that's something that you don't get under the state law. And again, that was what we were trying to encourage. We want to encourage people to engage in good behavior, what we consider to be good behavior. And the way we did that was by offering this carrot. And somehow below, the court found that this justified enjoining the city from enforcing the entirety of a chapter of its municipal code. That was wrong. For those reasons, I ask that you reverse what the trial court did, remand with an instruction to grant the motion to dismiss because it never should have been in equity in the first place. If there's any other questions, I'll reserve the remainder of my time.
So you've carried over 2 minutes, and so I'll,
About 2 minutes?
yep, so no, what I'm saying is you have 7 now.
Oh, wow, okay.
Okay.
Morning. May it please the court, counsel. I'm John O'Shea on behalf of Mr. West. One thing I want to mention at the outset, Your Honors, is if 915.3 truly mirrored 2919.22 and the city added the safe storage component, which would be an affirmative defense, we'd have no problem with it. But the foundation of the city's argument, which is...
Oh, wait, you lost me there. So you're saying if the city has something related to storage, even though 9.68 talks about storage, that's okay?
Well, no, what I'm saying is if they made the rights of the individual stronger, and the threshold of that is 915.3 does not mirror 2919.22. It's a lower culpable mental state, and it also takes from the fact finder what is...
So I understand that, but I just want to make sure I understand what you were just saying, because I felt like you were saying the city can regulate storage in some respects.
No, it would be superfluous if it, I don't think it's a necessary issue, but I think 915.1S would be superfluous to this conversation if, in fact, 915.3 mirrored 2919.22. I guess but it's probably an argument that just is not really relevant.
Okay.
Can you explain, though, how does 915.3 regulate storage of firearms?
915.3 regulates storage because it states that, let me just get my notes so I do it correctly, Your Honor. They take from the fact finder what is a substantial risk of harm to or the safety of a minor by saying to negligently store a fire or leave a firearm in a manner or location in the person's residence or vehicle where the person knows or reasonably should know a child is able to gain access to the firearm, whether or not that child does gain access to the firearm.
But it's not telling people that they have to store a firearm. It's just saying if you don't store a firearm and it's picked up by a child, then you're in violation of the law.
Well, it doesn't say if it's picked up by a child. That's irrelevant to the evaluation.
Endangers or whatever the words are, but.
No, it says where the person knows or reasonably should know a child is able to gain access. It doesn't matter if the child, let me give you an example, okay? My daughter, 17-year-old daughter, I signed her into the Marines early. I pick her up at CVG when she gets back 2 days before her 18th birthday. I have my firearm in the console of my car without a trigger lock on it, and the console's unlocked. I drive her home through the city of Cincinnati. If I stop in the city of Cincinnati and to buy a bottle of water and leave my daughter unattended in that car, I violated 915.3. Whether she even knows the gun's there or not. If I wait to get to Norwood on Montgomery Road and stop there, then it becomes a question of fact for the fact finder whether those set of circumstances, if I recklessly created a substantial risk to her safety, it would be a fact finder question. First of all, whether that was a substantial risk to her safety, whether I created it.
So you're
Okay.
saying that it comes down to opportunity of access? That's what it
Well,
sounds
that's, I
like
mean,
to
I
me.
think that's what the city ordinance says.
Right. So the actual
Opportunity.
access is inconsequential.
Absolutely. I mean,
So if the city rewrote this to address your concern and said, it's only a problem if you allow the firearm, it's sitting out there and the child accesses it and does someone harm, is that okay?
no, that's not what I'm saying. I'll give you.
Well, but I think we're talking about all these hypotheticals, and I'm just trying to understand what your ultimate point is. And if it's not that one is okay and one is not okay, if they're all not okay, then I think we should be talking about something different.
No, the issue is, if you evaluate 915.3 relative to case law in 2919.22, okay? State versus Wyatt was one of the cases we cited. The court held, quote, in the Court of Appeals reviewing the jury verdict, finding the guy guilty, okay? In a light most favorable to the prosecution, the evidence shows that the defendant, 1, had a loaded semi-automatic gun on the floor of a bedroom, 2, 3, easily accessible to a 3-year-old child and a 4-year-old child. The door to the room with the gun was open.
I understand that, sorry to interrupt, but my point is, are you saying there's a way the city could have drafted this to address your concern about any sort of conflict with
Yeah,
state law?
they-
Explain that.
Well, they did it in 915.5 with the preface to 915.5 is verbatim from the weapon under disability statute in the
So 915.5 is okay?
It is.
Then why did the court enjoin that?
Well, here's the deal. That was probably an inartful argument on my part. But obviously, this court can limit the injunction as it did in Winley versus the Miami Township Board of Trustees versus Winley. It limited the injunction in that case, notwithstanding what the trial court ordered.
Right.
And I am representing to you now that our position is 915.5 is okay.
Okay.
All right?
Thank you.
But the point is, that Wyatt case that there's 10 factors the Court of Appeals reviewed to see if the case, the finding beyond a reasonable doubt by the trial jury was sustained by the evidence. And again, taking it in the light most favorable to government, that's fine. But the point is, they go through that analysis. And the problem here is if you just read the plain text of 915.3, it's at best a negligence mental culpable state. It's arguably a strict liability by imposing on a custodian of a child, someone under 18. And again, I mentioned in the Wyatt case, the Court of Appeals considered the ages of those children. There were 3 and 4. This goes up to the day before your 18th birthday, and it's again, a strict liability offense for all intents and
So
purposes.
this is your issue, and I understand what
Yeah.
you're saying. Your issue is with Part B, taking this away from the fact finder.
Absolutely.
But what about Part C, the so-called carrot that the city is
The
arguing?
safe storage.
Yeah. Well, is
Again-
that a problem? Because that basically says if you store your firearm safely in certain ways, then you can't be charged under this.
Right, but there's no law in the state of Ohio that requires a certain way to quote-unquote safely store
Then
a firearm.
then how does it conflict?
What's that?
Then what's the conflict?
Because that would violate 9.68 also.
How?
Because it's mandating how to store a firearm.
It's not, though. It's basically saying you can store the firearm however you want, but if you don't store it safely, then you can get charged under the statute.
It's almost an ergo, though. If you don't store it safely in your home or your car, and there is someone under 18 years old in the same vicinity, you violated 915.3. They can describe it as an affirmative defense. It's really a definition on how you have to have a firearm around a child. I'll give you another example.
It does with B. I mean, so if B were somehow severed and you only had C, then, I mean, if B were severed out, would you still have a problem with the statute? Because you don't like how it takes it away from the jury to determine whether or not there's a substantial risk. Because if you're dealing with somebody who's just shy of their 18th birthday, that would be problematic, you're saying.
I can't read 915.3 in a vacuum without B, because I think I would think because C would, when you're instructing a jury, okay? A jury's going to hear C, let's say it's C still, you leave B out, and they're going to hear C, and they're going to say, well, he didn't safely store the firearm. Like I said, they describe it as an affirmative defense. I describe it as a mandate.
But
as
wouldn't
to-
that come into even a violation under the state law that the person left a firearm on a coffee table loaded when children are around,
That was one fact.
right?
That was-
That's
but that
going to
was-
come in no matter what, and the state's going to argue that the defendant didn't safely store a firearm in any child endangering prosecution, right?
Well, sure, and if you, I mean, I guess the flip side is, if you take Wyatt or any of the other cases, at least you take Leak or Howard, if I have, under the City of Cincinnati code, safely stored a firearm, that's going to be a practical defense to a complaint for child endangering. I mean, it's going to be a
then
fact,
what's the problem with the city putting that in an ordinance?
because it makes it look like it's mandatory. And let me give you another example.
It doesn't say thou shalt store a firearm under all circumstances in
Well,
this
if you
manner.
excise B out, yes, it's less offensive.
Well, let me go, I want to make sure I understand your position on mootness. I realize I'm shifting grounds, but.
Okay.
What is your position on whether this dispute is moot at this
Yeah,
point? Because my understanding is he cannot be charged now under the city ordinance because of the disposition of the state charges, under just basic double jeopardy principles.
well, that's the question. Is it double jeopardy? Now, is it double jeopardy if the city were to file a notice of appeal within 30 days of the decision on the state statutes that survived the motion to dismiss?
I mean,
I don't know. I mean, I couldn't find any authority that would say, and maybe you have some, but there's an appeal date that's still running.
sure,
Okay,
okay.
could the city appeal the dismissal of the 915.3 complaints in the criminal trial court?
So
That's one issue.
let's say we go 30 days, there's no appeal by the city. What's your position at that point?
Mr. West is still harmed. First of all, he was charged by the city unilaterally with the 915.3 violations, by the way, 6 weeks after the incident, okay? Late May, April 1 incident. While that criminal case was pending, we filed the 9.68 complaint. While that was pending, we had a hearing, and again, we've talked about the injunction being issued, but an injunction was issued, which the city appealed, okay? So they decided unilaterally to appeal it. We're still defending Mr. West in criminal court because they unilaterally decided to file the 915 claims, and it gets dismissed,
Right.
right? Well, it's not our appeal here, okay? The city unilaterally decided to appeal. So we have to continue defending Mr. West.
But you're done. He's prevailed on
But
that
we're
claim.
we're the appellee. We can't dismiss the appeal.
I'm not asking you to dismiss
Okay.
the appeal. I'm
So-
just saying, is it your position that after 30 days runs and there's no appeal by the city, that Mr. West has standing to continue to defend this injunction?
what I think would happen is if this court felt that the appeal was, the city's appeal was moot, you dismiss the appeal and remand it back to the trial court, the common pleas trial court, for a hearing on damages. That's what I think, because again, the point I was trying to make is they've pursued this, both in this court now on the appeal, and they pursued it in the municipal court criminal case. We were forced to defend ourselves to something that, in our opinion, is clearly violative of 9.68, okay? That doesn't change by virtue of the fact that he won. I mean, is the city taking the position that, hey, since we won, his appeal is moot, and everything's moot, and we don't have to worry about paying
Well,
damages?
but the injunction is to prevent people from being charged as he was under these circumstances. And now that he has been found guilty of one offense and been exonerated on the other, he's not at risk of being charged under
Right,
this.
but he's got damages from defending himself in the process, and that's what 9.68 provides for.
So just to make sure I understand, your position is because those damages are still in play, it's not a moot dispute.
Well, and we also have the declaratory judgment action in the trial court, but yes, that isn't going to change. And that's what 9.6, and you actually mentioned it in that Kellard or whatever case it was, the city of Kellard versus City of Cincinnati, where the guy was an employee and he was afraid to keep his gun in the car because of a city regulation. Okay? You mentioned the Oberlin case, and you said that the attorney's fees are important to prevent cities from passing ordinances that violate 9.68. That hasn't changed, because, I mean, it's kind of like, again, the city touting their defeat. I would submit that losing on a motion to dismiss pre-trial in the trial court would be directly analogous to what the legislature wrote in 9.68B2. It's analogous to after us filing, and in Kellard, he got his relief within 4 days of filing his complaint. Okay, we've been going through this for months and almost a year now. And the problem is that cost money to Mr. West, and that caused him to incur damages. But again, the point is nothing of it changes because the city lost. And like I said, it's analogous to the city the city repealing the ordinance after the lawsuit was filed. We're still in the same position.
Okay, thank you.
Thank you for your argument this morning.
Thank you very much.
Well, if
You have a
you're-
whole 7.
I'm usually, when you said
Whatever
two,
shall
I'm
you
so
do with
used to
that?
I'm so used to, you have 2 minutes left, that's what I
Yeah,
thought
I
you
know
were
you
gonna
missed,
say.
I should have said an additional 2.
As Mr. O'Shea just told you, if you were looking for a reason why this is not moot and why this is still a very live controversy, it's because he's seeking attorney fees and whatever other monetary damages. Now, on there, he's going to run into a little bit of a hurdle because he's relying on the amended 968, which has been properly preliminarily enjoined, and at some point might face a proper permanent injunction hearing, unlike what happened here. But at the end of the day, he couldn't bring this matter in equity. He had a pending criminal case. He had to go to the criminal court, and I think we know now why he came running to equity, and it wasn't because he didn't have an adequate remedy. It's because he didn't have the adequate remedy he wanted. He wanted to be able
Yeah,
to
but
get
I mean,
attorney fees.
9.68, says you can do that.
No, it doesn't.
It says you can bring an injunction claim, you can bring a declaratory judgment claim.
Oh, well,
I
it
mean,
does
it's
say
a
that.
pretty
yes,
broad,
yes.
it's a pretty broad statute.
And
It
it also
does.
says in doing so, you can be awarded damages.
I'm sorry.
And it also says in doing so, you can be awarded
I
damages.
I
even
agree,
though-
I agree. But when it created the injunctive relief, it did so in a generic, you can seek an injunctive relief. And the Ohio Supreme Court has said that when you have a general, you can go get an injunction if you want it. That's fine, but the general rules of equity still apply unless the legislature has crafted some type of special provisions in there that overrule the general rules of equity. And the general rule of equity is, if you're in a criminal case, unless it's a clearly unconstitutional law, and involves a substantial infringement of your property rights, you don't get to go to equity. You go deal with it in the criminal court. And the legislature hasn't given them attorney fees in the criminal court. That's been their call. They've put it only in the 968, only in the amended 968. And that does not change the general rules of equity, which say if you have a pending criminal case, you go deal with it in the criminal court. That's your adequate remedy at law. And here, he had that adequate remedy. We told him repeatedly, that's where your adequate remedy is. It was only after we said it repeatedly that he finally filed the motion to dismiss in the criminal case, where he ultimately got that
Let me
relief.
make sure I understand your position on Section B of 9.68. You're basically saying that pre-existing principles govern when there is a criminal case, right? I
Yes.
think that's, summing it up, that's pretty much it.
That's it.
Okay.
Yeah. And on his examples about the person who's 17 and just came home from basic training, look, we have arbitrary age cutoffs of 18 or 21 for firearms because that's the age of majority and adulthood in the United States. The fact remains is that you'd have to know that they would improperly gain access to the firearm.
But his
And-
example kind of demonstrates that, and his argument is that you're taking the jury's determination of what is a substantial risk away from the jury, and you're telling them what it is.
No, we're just saying what the definition of a substantial risk is. They still have to apply all the elements in there to see if those factors that, did you know that the child was going to gain access to this firearm?
Well, wouldn't his example with the person that is almost 18 but not quite 18 be the parent would be in violation of?
No.
How would they not be in violation of the statute? in
It
that?
would be no different than any other child endangering, and I cannot remember the name of it, but it was one that I handled when I was a criminal prosecutor, where there were kids that kept leaving the house and running around and riding their bikes in the streets. And the police kept coming to him saying, hey, you knew this. You knew that these kids are doing this. And eventually, that became child endangering because you knew if you left the kids unattended, they were going to go run around in the street and maybe get hit by a car. If you look at other cases where, like, you leave the child in the car to run in to buy the bottle of water, and they knock the car into gear and they get hurt, if they've never done that before, then you have no reason to know that that's ever going to be a situation.
But
and
the
you're not gonna get
Ohio
charged.
child endangering statute doesn't define substantial risk, right? That's up to the jury to decide what is a substantial risk.
Case law tells us what substantial risk is. And I
Right,
don't
but
see
that
any,
wouldn't be in a jury instruction.
the jury instruction would give that definition of substantial risk, where they would still have to find all the different elements in there to say that, yep, that's what happened here. That firearm was left out someplace where where you knew or should have known that child was going to improperly gain access to it. And, ultimately, from what happened here, that's kind of where Judge Mallory split the hairs below when he acquitted on one and found guilty on the other. He said, you trained your own child in how to use firearms, so we're going to acquit you on that. But the kid's friend who actually pulled the trigger, you never taught him how to use guns, so there's the child endangering. You left a firearm someplace where you knew or should have known that somebody who didn't know what they were doing was going to improperly
That's
gain
under the
access to it.
Ohio law. How would that have turned out under the city's law?
Exactly the same. And frankly, they're allied offenses. I've said that below in both the civil and the criminal case. These are allied offenses. As far as if we were going to appeal what Judge Mallory did in the criminal case, I don't think that we are, because ultimately we would be getting a ruling on whether or not our ordinance was okay, but at most we'd be able to get a finding of guilt. They wouldn't be able to get a true conviction because they're allied.
It's funny that you said that because that's one of the things I was thinking about when I went through this case was the allied offenses. And I was surprised, not to read of anyone raising that.
I don't know if it's really relevant to the arguments
I mean,
here, but no,
I
that was
understand.
certainly one of the things that everyone below kept saying that the city's ordinance and the state law are so vastly different, and the only difference is that we're encouraging safe storage. Other than that, I've always used the word generally because they don't perfectly mirror each other because there is slightly different language there, but the big difference is that we're giving Cincinnatians an extra right that you don't get in the state. That under state law, it doesn't matter. If you put your gun in a safe, but they somehow managed to gain access to it and you knew they were going to be able to gain access to it, Well, the state law doesn't care. The city is saying, you know what, you tried. You engaged in safe storage. We're not going to charge you under the Cincinnati Municipal Code. The Ohio, the revised code, that might have something different to say about this. But under the municipal code, you did what we asked you to do. And, again, it's an ask. It's not a thou shall. It's we hope you will.
So C is not an affirmative defense. It is basically saying you cannot be charged at all.
Shouldn't be, and if you were, then I think it would become an absolute defense.
Well, it says this section does not apply to a
Yeah.
person who does the following.
So you're right, it's probably stronger than an affirmative defense. I may have been wrong calling it an affirmative defense this time. It should have been just an automatic grounds to have that dismissed. Although it would, again, it may become a question of fact, was it really in safe storage?
Right, you have to litigate that whole, would
That
that be like
might
a
be.
pre-trial kind of thing?
Maybe. And that, again, I think that's why I've always considered it to be the affirmative defense, because you can say, I use safe storage. A twist tie is not safe storage, But at the end of the day, there is no conflict between the city's municipal code and revised code 968. And even if there was, the right place for that was in the criminal case. That's where it was ultimately really resolved. And that's where it should have been the whole time. And just because the legislature is not given attorney fees for bringing it in the criminal case, doesn't change that's where you got to go. You can't just go running to equity because you like that remedy a little bit better.
Thank you for your argument this
Question is if
morning.
you've got the adequate remedy.
Thank you.
So ask that you reverse and remand with instruction to grant the motion to dismiss. Thank you.
All right, thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. We wish you both a wonderful afternoon. Good morning. City of Cincinnati versus State of Ohio. Good morning.
Good morning, Your Honors, and may it please the Court. My name is Elliot Geiser on behalf of the State of Ohio. I would like to reserve 2 minutes of my time for rebuttal. This case is not just about firearms, it's also about precedent. Cleveland binds this court and requires reversal of the trial court's preliminary injunction. Cleveland expressly held that the original version of the firearms uniformity law is constitutional, and whether you look at the original or the amended version, Cleveland's application to the Canton test leaves this court with no room to hold that the firearms uniformity law violates the Home Rule Amendment. There are only
And let me ask you this, let me understand the state's position. Is the state's position that municipalities like the city of Cincinnati have no ability to legislate anything that touches on firearms? Is that the state's position?
No, as we said in our brief, they
Then-
can legislate on firearms, but they can't create further restrictions on firearms beyond.
So explain to me what the city could realistically do under the state's perspective.
So the city can create laws that mirror or are less stringent than Ohio or federal law on firearms.
Less stringent?
Less stringent.
So,
The
so can
same
you give
or
me an
less
example of that?
So I think that the dialogue that was happening earlier in this court about whether or not you can create an affirmative defense, any of these individual applications, I'm not going to try and create a bright line at oral argument here, but the clear text.
That's my
of-
job, to make you create a bright line rule.
Well, the bright line rule is that you can't do anything further than what the General Assembly.
So what you're
and
saying,
federal law.
the state's position is that if the city wants to deregulate further, then that's okay. They just can't regulate anything that would place any restriction on the use of firearms.
Yes, so regulations always create borders between rights and duties.
Sure.
And the General Assembly is creating rights that are affirmative to the people of Ohio so that you don't have to worry about the patchwork of laws that could be created by Ohio's 1,064 towns and municipalities. You shouldn't need map in one hand and Westlaw login in the other as you drive from Cincinnati to Norwood or any other part of the state. And that's the overriding interest here.
So if the state said, you know what, we don't really like environmental laws, and we want to get rid of those, and we now want to prevent municipalities from regulating environmental, any sort of environmental issues. Is that okay? Like, could the state do that?
Well, so under the Canton test, Your Honor,
Yeah.
the way that we would analyze that is whether or not there's a comprehensive, uniform scheme of environmental regulation that the state thinks needs to override anything that's contrary. Now, something can be less stringent than maybe a city would prefer and still be comprehensive because it can allocate rights and duties in a different place than maybe a municipality would like. But as long as the allocation of rights and duties is being done in the first instance by the General Assembly, we think that that is a general law for the purposes of the Home Rule Amendment. The Home Rule Amendment creates an enumerated reserved power to cities. Plenary power rests with the state. And there are two components to the Home Rule Amendment, of course. There's the local affairs of self-government, which is exclusive, and then the second part is a conditional authority over police and sanitary regulations. And so here, when it comes to firearms, the General Assembly has said, we have comprehensively regulated and allocated rights and duties with respect to firearms. So if you look at the constellation of firearms regulation in the state of Ohio, the best way to understand 9.68 is it's the North Star that incorporates the rest of that by reference, almost like a complaint incorporates the remaining previous factual material. It incorporates all of federal and all of state law on firearms, and then says, you're to read the rest of that constellation. And that constellation is comprehensive. We regulate the who, the what, and the where of firearms in all kinds of different ways. So if you're a person under disability, if you're a felon, if you're someone who has a restraining order ended against you.
Are you talking about our analysis of the comprehensive scheme with regard to the first prong, that it's part of a statewide and comprehensive legislative enactment? Or are you saying that we look at the comprehensive scheme for every prong?
Well, I think that if you are analyzing, there are only 3 of the 4 factors that are at issue here. 2 of them were relied on by the trial court. The Cleveland versus State opinion analyzes the uniformity and the comprehension at the beginning, and then
Right.
it uses the logic of that understanding under the 3rd and the 4th prong.
So, because that's where I'm a little bit confused for the Cleveland case. It talks about RC 9.68 establishing police regulations rather than just limiting municipal legislative power. How does 9.68 itself establish police regulations?
Well, I think there are 3 ways that you can look at that. I'm glad you asked, Your Honor. So
Okay.
first, the express incorporation. That's what my answer to Judge Bergeron about, where it says, as it's provided by the Ohio and the federal Constitution, the federal statutory scheme related to firearms, and the state. All of that comes with it. It's soil that is carried with 9.68
So
subdivision
the
A.
text of 9.68 itself doesn't establish any kind of police regulation. Would you agree with that?
No, I wouldn't. So that's my second and my third point. My second is subdivision B allocates rights to individuals. And so allocating a right to an individual by creating this scheme for pursuing attorney's fees and pursuing injunctive relief, pursuing other kinds of remedies, that is a regulation on individuals throughout the state.
Giving them the right to sue and get attorney fees is a police regulation?
Yes.
That seems to be a stretch. I mean, you're just saying, like, you can get damages here, but it's like, that's not regulating what you're doing with your firearms.
Well, Your Honor, I think one of the confusions of the trial court's opinion here is it thought that a regulation has to be proscriptive. It can't be prescriptive. It can't offer a correlative right along with the duties.
But in
of-
B, what is it, what, proscriptive or anything else, what is it saying about firearms in B?
It's saying that individuals who abide by state and federal law have the capacity to go to court and ensure that their statutory rights are not invaded by some other entity. Now, the only entity that is capable in the state of Ohio invading those rights in a meaningful way happen to be political subdivisions, but that's incidental. That's not the target of subdivision B. Those are the only
I
entities that could
understand what
actually-
you're saying is Section B is a remedy, right?
Yes,
Section A is the regulation, Section B is a remedy.
right, yes.
So it's
And-
collateral to Section A.
Yeah, they do interact together, Your Honor, and I think subsection.
Right, you don't sever them. because that would make any sense.
That's
You know,
correct.
you're gonna sue about what and B, you know, but, yeah.
Right, and I think also subdivision C and D, which hadn't gotten a lot of attention from the trial court, they also establish individual regulations. So subdivision D makes clear that if you have a neutral zoning regulation, there's nothing in 9.68 that is trying to take away cities' authority over saying, well, you can't have manufacturing, for example, in this part of the city. This is residential.
I have a question that takes us to a different gear, okay?
Okay.
So when it comes to knives, is there statewide comprehensive regulation legislation with regard to knives? Because knives was added, was part of was the 2022 amendment.
Yes, and there are laws that have to do with knives. I mean, 2923.11 talks about dangerous ordinance. It talks about other types of things of that nature. And there are regulations at the state level regarding knives.
But how does that conflict with, or would anything with, I mean, this is about firearm regulation, so what does knives have to do with anything?
Well, so we think that's another reason to vacate the preliminary injunction. The injunction ran against enforcement of the 2022 amendments, which were supposed to ensure that individuals also have knives added to definition section C, subdivision C, and then also in subdivision A.
Could you be
So-
specific on a provision in state law that regulates knives?
I mean, I already offered one, 2923.11. I don't have in front of me all the regulations that we have on knives in the general
But I
assembly.
mean, just generally, like, don't worry about a citation, but like, what regulations cover knives? Is there a
Well-
felon in possession of knives statute or something like that?
I'm not aware of a statute like that. There might be, but I think the easiest answer there is the general criminal law of the state prevents you from using a knife against other people. And I think that general criminal law actually is important here. And, you know,
But that
your
has to
court
do
hears-
with criminal use of the knife as a,
Yeah, criminal use of the knife isn't the same thing that you're always thinking about. I think that one of the problems of the trial court's analysis here is it said, well, criminal use of firearms, that's obviously not something that we're talking about at all. And actually, that is part of the constellation of regulation. That
right,
is
but there's
involved.
also regulation providing the right to have firearms.
That's true, yes. And so regulations can say, here are the circumstances under which you can use firearms, and here are those that you can't. And here are the types of guns that you can use and where you can use them. So the who, the what, and the where. You can't have an automatic firearm in Ohio. You can't have a sawed-off firearm, sawed-off shotguns. You can't carry that. You can't go to a school zone, or I couldn't bring into this courthouse a firearm. You couldn't bring a firearm into any of the liquor-oriented establishments where liquor's being served, absent some very defined and delineated prescriptions. And, you know, I think the trial court really got off the rails by saying, hey, we think that the regulation is not stringent enough, and therefore it's no longer a police regulation at all.
Because what
And-
makes knives interesting is that it is, you know, it is under weapons, and there's a lot of things that are under weapons besides firearms
Correct.
and knives, okay?
Correct.
A lot of stuff. But yet, all that lot of stuff is not really regulated.
Well, so again, if you return to 2923.11, there's a definition of dangerous ordinance, and that's capacious. Lots of things would fall under that definition, and there's a reason for a capacious definition of that. It's not something that people ordinarily use as part of their Second Amendment or Ohio corresponding right to keep and bear arms. And so the state is regulating across the field. Now, the city might have a policy disagreement with the level of stringency that is involved. But the remedy for that isn't a legal one. There's nothing in the Home Rule Amendment that is a problem with that.
So let me ask you this, going back to like weapons under disability, what if the city said, you know what, we're fine with people who've had various convictions having firearms. We're getting rid of that. We're being less stringent. Is that okay?
I mean, I think that would not likely be in conflict with any of the general revised codes provisions. I'm trying to think of an example of where that would come to a head, where there's a situation. I mean, would the city intervene in a criminal prosecution on behalf of the state for someone who is unlawfully possessing a firearm and say, hey, we've deregulated that? I mean, that seems like such an improbable circumstance. But I think the thing that is important here is that the General Assembly, taking a page out of the American Financial Services Association case, where the Ohio Supreme Court offered the General Assembly guidance and said, hey, you can declare your intent that your comprehensive scheme be interpreted as a general law that preempts conflicting laws. And so 9.68 reincorporates that, applies it to persons, and then creates a way for the judiciary to say, hey, look, if there's a conflict, the General Assembly really intended that the general law prevail.
So with regard to, there's the City of Dayton versus State case, which I know is a plurality opinion, but in that case, Justice Fisher in the lead opinion said that for the third prong, that we have to analyze the contested provision individually. So I'm just asking if what you're saying is that when we're looking, I'm just talking about the third prong here, are we looking at just as 9.68, the language of that statute in and of itself? Is that what we're looking at, or are we also looking at the comprehensive scheme for the third prong?
Well, so I would say this court should do both, and the reason is Cleveland versus State expressly said you got to read 9.68 in pari materia, and that's
But not in the third prong section. I mean, it didn't expressly say that when it was talking about the third prong.
that's true. It didn't use pari materia when it was talking about the third prong, but it did hold that it was a regulation that established police regulations, and so. How do you reconcile that? I think that any overruling should be done by the Ohio Supreme Court and not by this court.
It was kind of a conclusory thing in that case. I mean, you're just saying we have to follow it, period, end of story, whether it makes sense or it doesn't make sense. But it doesn't really analyze the scheme when it's talking about the third prong, right?
We would say that this court should follow it, and to make it make sense, that's why I offered these three, and I didn't get to the third one. But the third one is that it talks about a person in subdivision A. So if you don't accept that subdivision B is enough for an expression, and the city cites Mendenhall, paragraph 25 of Mendenhall talks about how the no person language in the statute that was at issue there means that it's a police regulation.
So
So-
you're saying in Part A, it talks about the individual right, or where does it talk about a person?
So if you go to the full text, it says, except as specifically provided, a person without further license, permission, restriction, delay, or process, and then shall be able to, and then a list of verbs with respect to any firearm, part of a firearm, its components, its ammunition, or any knife. And so that's a police regulation because it's dealing with individual people, and it's also under prong 4, prescribing rules for citizens, not just.
It's not regulating anything, it's just saying that you have the right.
Well, it's creating a regulatory scheme, and so regulatory schemes create affirmative liberties and can also create affirmative duties. And so the first clause of that sentence says your duties are to follow state and federal law, and your corresponding right is that you don't have any other burdens besides those. And I think that's really the overriding interest here. The trial court said there was no overriding interest because uniformity can't just be an overriding interest, expressly contradicting the fact that the Ohio Supreme Court said uniformity in the area of firearms is, in fact, an overriding interest. And that overriding interest is that it allocates certainty about the rules you're supposed to follow as a law-abiding gun owner to the individual. And the individual says, yes, I can be certain if I follow these rules, I don't have to worry if I happen to pass through a city with an inconsistent municipality that I'm going to be charged and my liberty is going to be taken away.
Thank you. Unless there's any other questions, I'll reserve your time.
Thank you very much.
Good morning.
Good morning.
How are you doing?
Good. May it please the court. I would so want to spend the entire 15 minutes discussing the merits, but we have to start with the jurisdictional issue. This appeal is premature. The court should decide that it lacks jurisdiction for lack of a final appealable order. Preterm Cleveland controls, and it controls in three ways, if I may quickly outline them. The city is seeking not just a preliminary injunction, but also a permanent injunction. So that means the state, just like the state of preterm Cleveland, has a meaningful and effective remedy at the end of the proceeding below. So following the permanent injunction ruling, if it so chooses, it can appeal.
How is this injunction preserving the status quo?
Most importantly, Your Honor, it's because the trial court only limited it to the amended 968. It didn't go back to the original 968. That would have disturbed stare decisis. The city brought it, the first iteration of this lawsuit 6 months before the first amended 968 went into effect.
The 2018 amendment?
Yes. As you know, there was intervening litigation that proved meritless, challenging the solicitor's authority to bring suit. It resolved, but it took 3 years to resolve. And during that time, the city appreciated that the state had amended 968 even again, and so dismissed the complaint, refiled it within 2 days. That kind of convoluted procedural history is kind of what we saw in preterm Cleveland. So the question is, did the trial court place the parties back in the last peaceable, actual, uncontested status prior to the pending controversy? And that's what it did. Then it went on to held a full-day evidentiary hearing. The state put on no evidence, introduced no witnesses, barely cross-examined the witnesses, talked of no irreparable harm. The standard, as this court looked at in MedPace, is whether the party against whom the injunction is obtained preliminarily, is subject to some irreparable harm between the preliminary injunction and the permanent injunction. They're not. There's, as you heard, the state is saying, the city is speculating as to the injuries, the home rule injuries, and it's the city that the trial court noted would be harmed in the absence of the injunction. And
Can you say how, there's a case out of the 10th District, City of Columbus versus State, that did find that it was a final appealable order.
Yes.
Can you distinguish that case?
Yes. Well, not only did that trial court enjoin the original 968, it also, the court also found the evidence was stale there. So here, the evidentiary hearing was in June of 2023. The trial court issued its preliminary injunction ruling in September. The evidence was fresh. And so so the state, even less than in preterm Cleveland perhaps, has no claim to an appeal at this juncture. It should be turning back to discovery so we can get to the the permanent injunction ruling and discovery on all the claims. And then, all the parties, there's so many audiences that are waiting for this court and the High Supreme to rule on the merits, but
Well,
it's
so
premature.
let's shift to the merits. I appreciate those arguments. Can you help us out with how we should analyze Dayton vis-a-vis the City of Cleveland case, and whether the City of Cleveland should be controlling on the third and fourth prongs as compared to the Dayton analyses?
Sure. So, yes, so I think the starting point for Dayton is that, and as the Supreme Court, noted in Dayton, said every home rule case involves a unique set of facts, right? No two statutes are exactly identical. And despite what the state has been arguing, this is not a statute. The amended 968 is simply not doesn't just clarify a few aspects of original 968. Actually, as this court noted in Kellard in 2021, the attorney fee provision in 968B made obsolete the attorney fee provision in the original 968. So the point I'm making there is that you're going to have to do a fresh Canton analysis. Now, going back to your question, Judge Krause, on Dayton and whether to view it in isolation versus looking at it as part of the comprehensive enactment. Well, the trial court was certainly deferential to the City of Cleveland in the sense that it for the first prong about whether there was a statewide and comprehensive enactment, it deferred to the City of Cleveland.
Well, it was very clear.
Despite the evidence, right, that the field has been gutted. We have permitless carry. We have basic competency requirements no longer required, no training.
But a lot of the statutes that were mentioned in Cleveland, as far as the first prong, are still in existence. There's many that are not, but there's many that are.
And as we started to get to in our evidence,
And I want to add something. It seems as if you're defining regulate as limiting rights as opposed to including expanding.
sorry.
And you said that it's been gutted
the
because of no
yes.
concealed carry. So
So-
it seems as if you are defining regulation as limiting rather than expanding.
Well, that's what 968 does by its, facially. If the state was correct in that 968 simply barred municipalities from going further beyond, then 968B would not read the way it does. It takes away the but-for causation requirement and simply allows any person who feels that they're adversely affected, as we saw in West or other cases, to formally question the city, not even bring a lawsuit, simply challenge the resolution. If we passed a resolution on knives, that was enough to trigger 968B under the amended 968, and they could get attorney fees, not even having to show causation. All they have to show is that they made a formal questioning of the policy. So in Dayton and Cleveland, looking at those two cases, the question becomes whether there's an overriding state interest. I believe that the way to read it is that if there's no overriding state interest, then statutes in isolation can stand or fall based on what they're doing. If there is an overriding state interest, then as Cleveland was looking at, they were looking at the comprehensive framework. The point for today, I believe, is that the trial court did exactly what it needed to do. And remember, we only have one sole assignment of error from the state, that the trial court was wrong on its analysis under likelihood of success. This trial court did exactly what it needs to do. It applied Canton. It was deferential. It was just a conservative ruling below.
But it didn't follow the third prong in the Cleveland case.
That's correct.
It didn't blindly follow it.
Oh, no, so, sorry, when I say it followed it as respect to the first prong.
Yeah, and
Yes.
that's, nobody's arguing about the first
Well,
prong,
because
right?
the statute that was in front of City of Cleveland in 2010 was not the statute that was in front of the trial court in 2023. It went from 326 words to 662, and it wasn't just the words.
But like, the thing that Judge Costa's been asking, that I've been asking, is how do you reconcile the Dayton analysis with the City of Cleveland analysis with respect to the third and fourth prong? So could you share the city's perspective on that?
Yes, so 968, so Dayton talks about studying those statutes in their individually, right? So, in 968 purports to, it prohibits the municipality from enacting or even addressing in any way, even through acts that have no legal effect, resolutions, a broad range of activities that weren't under original 968. There's no overriding state interest there. And on the third prong and the fourth prong, on the fourth prong, the trial court found that's aimed right at municipalities. Youngstown found the same thing. And so it should fail on the fourth prong.
She also said that 9.68 doesn't establish police regulations. Didn't the trial court say that?
That's right. Where does it do that in 968? So,
Okay, but we have a case. We have a Supreme Court case that says it does.
the Supreme Court case from 2010. So
Yes.
that original 968 is closer in time to what our police chief testified was the state of regulation and state of gun violence when she first started in the early 90s than it is to what she testified in 2023. You know, in 2023, you can carry a gun, loaded gun within reach in a vehicle and not have to tell the officer that.
But we're examining statutes, right? Not circumstantial changes. We have Supreme Court precedent that the state is telling us that we are bound to follow. And you're saying we don't have to follow it, right?
Had the trial court enjoined original 968 in its order as well, yes, then we would, that would be a fair point, Your Honor.
So it's been amended so much,
It's
you're
been,
saying,
yes.
that this Supreme Court case becomes completely obsolete.
The Supreme Court informs the analysis, but Your Honor, but it does require a fresh analysis that can't simply blindly cite to City of Cleveland in 2010 when so much has changed, not in the statute itself and also around the statute. So it affects the home rule analysis, which you have to look at the statute. It also affects the first prong where you look at the comprehensive and statewide
That's why I'm
enactment.
trying to get to what do we look at for the third prong? Do we look at the entire statutory scheme, or do we simply look at 9.68?
So holding aside the jurisdictional issue then I believe City of Cleveland does say you don't merely, you look at both. Dayton never said you don't look at, it said you don't merely look at the comprehensive and statewide framework. You also look at the individual provisions, and you have to bring in the overriding state interests. So a proper analysis would take into account the overarching framework of regulation that has changed since 2006, and to see how much of City of Cleveland still applies. And the trial court was very deferential on that point and said, you know what, it's far from perfect. Supreme Court said in Cleveland, it doesn't have to be perfect. There can be gaps. We would say, when we get to the permanent injunction ruling, maybe it's so far from being perfect that doesn't meet that first prong anymore. But certainly it didn't need, and certainly one point to make is that the trial court can arrive at the right result for reasons that this court may differ, and it can certainly find and affirm on these alternative grounds. But the trial court took a very deferential stance on that first prong and still found that there was a likelihood of success on the merits because of how broadly the General Assembly went since 2006, went with their amendments. It's as if they feel that they can preempt municipalities according to this federal preemption concept.
Well, no, I mean, I think that was the gist of my question to opposing counsel, which is, this seems to me like almost the equivalent of field preemption.
So if any state is going to protect home rule, it should be Ohio. We're perhaps one of 10 or 12 states that constitutionally roots home rule authority. And in the state constitution, it's not legislatively created. It's over a century old. It was designed to push back on legislative abuses and to keep, home rule authority and democracy running at the local level. And
The
so,
original 9.68 seems to have to do the same thing.
in what way, Your Honor? Sorry.
The original 9.68 that was discussed in City of Cleveland versus state seems to do the same thing.
And in the court, in that case, in 2010, did take into account a plethora of other statutes and said, 968 then is part of a comprehensive statewide
For the first
enactment.
prong.
First prong.
Okay.
Yeah. Now, it also, so permitless carry has happened since then, and there's, so the things that that the Supreme Court was looking at in the City of Cleveland in 2010 don't exist anymore. It's to make training optional, the things, to make it optional to just have basic competency is a different framework that's in front of any court today. But the most important thing that faced the trial court below is that the fact that 968 allows anyone to use the statute because of its attorney fee provision as a punitive sword to nullify home rule authority in the state of Ohio, of all places, where the home rule should be stronger than in any other state. The legislature didn't create it. They certainly can't legislate it away through their statute making. And so that's why we feel the trial court was very measured in its conduct below. The state wants to blindly sort of cite to City of Cleveland in 2010 without doing the required Canton analysis. Trial court simply did that. And how did it abuse its discretion? The state stood on the sidelines throughout the whole evidentiary hearing. So we would ask that the court, in the first instance, decline to hear this appeal for lack of an appealable order, but, we'll be back.
Thank you. Unless there's any other questions from the panel? Thank you.
I would like to offer just 2 points. First on jurisdiction, and then second on the interplay between Dayton, Cleveland, and specifically paragraphs 27 through 29 under the third prong of Cleveland. On the jurisdictional issue, the question of effective remedy turns on not when a complaint is filed, but what the status quo has been harmed or changed. And I think that this court's decision in preterm Cleveland actually informs why that this is a proper appeal that this court can hear. The effect of the injunction was to set aside laws that had been on the books for nearly half a decade. The merits question about the third prong and the fourth prong. I think that's what's relevant about Cleveland versus State is in paragraph 27, it was talking about how the appellate court once again found revised code 9.68 had many gaps. That's the entire argument that the city of Cincinnati is offering right now, is that the gaps mean that it's over. And that is exactly what the Ohio Supreme Court analyzed in paragraph 27 and 28, and it held that we conclude revised code 9.68 establishes police regulations rather than limiting municipal legislative power. And then on prong 4, I think it's relevant that when we consider the entire legislative scheme, as we must, we conclude that when interpreted as part of a whole, revised code 9.68 applies to all citizens generally. So the fourth prong does have that language about considering the entire constellation. And I think that's what's important for this court's application. As to Dayton, it was a plurality. It only dealt with a third prong. It analyzed that statute. And as between a novel methodology supported by 3 justices and a conclusive holding on the same exact statute, I think this court should follow.
But Justice DeWine in his dissent says we should look at the more recent case law, and that's Dayton's more recent.
Well, Your Honor, as far as Justice DeWine's dissent goes, he was advocating that we go back to the original.
No, I get it. I understand.
And undo Canton altogether.
I understand that.
And so, you know, I think that Justice Fisher's analysis as to the Dayton statute is binding as to the Dayton statute, and the Ohio Supreme Court's Cleveland analysis as to the firearms uniformity statute is binding as to the firearms uniformity statute. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision, and we're going to go ahead and take a brief recess. Have a wonderful afternoon.
All rise. The Board of Appeals for the Flood District is now in recess.
Just a. I've seen the day. It's also by. Yeah.
You came this far, I guess you should see it through.
Absolutely. It's not we want to start the day, right?
London's good. I am.
Could have worse.
Let's look at it this way, maybe we can only get better.
Exactly.
right, good morning again, everybody. So our last case for the morning is State versus Johnson. Mr. Clark, how much time would you like for rebuttal?
3 minutes.
Very well.
May it please the court, and thank you for your scheduling indulgence.
Yes.
My morning was complicated.
No worries.
There was, starting about a decade before Kevin Johnson's trial, a critical reappraisal, not of the admissibility of fingerprint evidence. I think that there's a suggestion in the state's briefing that this is a case about admissibility. It's not. It's about reliability. And that critical reappraisal looked at how pattern evidence comes into criminal trials. Couple of things that are important here. First, testimony that pattern evidence is an objective methodology is simply not true. When a expert testifies about looking at one pattern and comparing it to another, that is a subjective method that requires judgment.
I mean, Mr. Clark, the issue I have trying to understand kind of your all's position is typically in post-conviction when you're challenging an expert, you're either saying, this expert got it wrong, we've got new evidence that shows the expert was just wrong, or you're saying that expert was relying on junk science and further scientific developments have shown this is junk science. I feel like what you're dealing with is not really either of those, and I'm just trying to understand how we're supposed to analyze that.
I think that the rationale, this is a very interesting procedure because of the 16K issue that happened at trial. Trial counsel said that he was performing from a deficit from the beginning because he was not even aware that fingerprint evidence was going to come into the case. Right. That kind of begins to look into the Strickland claim we raised about how Detective Horning's testimony was handled by trial court. But also, a NAPIU claim doesn't require changes in science. It's if there's false or misleading testimony that the state brings in.
Right, but I feel like your argument is not that this is necessarily false or misleading. You're basically arguing that the expert kind of exaggerated the reliability of her conclusions.
Our expert at the post-conviction hearing, Michelle Triplett, did testify that a number of Detective Horning's statements were misleading. And they're
But before we get to that, and you can tell us what was false, but what you did not do was have your expert actually do an analysis of the fingerprint, right?
That's correct.
So we don't know if ultimately what the detective testified to was false in that regard, that it was a match.
Well, there has to be some weighing of confidence in that conclusion. That's the conclusion. And
Right.
what
We
was-
don't know if the conclusion was wrong.
What we know is that her testimony about the methodology that she employed, her testimony about the science and what science can support was false.
Okay, so what were the false statements that she made?
She said that this was an objective comparison. It's not.
Well, didn't she admit, though, in cross-examination, that it was subjective?
Yes, and on to that, I would ask you to look at Gomez, the Connecticut case that we cited that talks about the fact that it is fundamentally the prosecutor's obligation to correct false or misleading testimony.
Do we have any evidence in the record that the prosecution knew that her statement to begin with, that this was an objective process, was false?
There was, I mean, yes. The context in which this case was litigated should give you that because in 2009, the National Academies of Sciences report comes out and says...
But that wasn't in the record until the post-conviction hearing, so how would the prosecution have known of the NAS report?
The Brandon Mayfield case was on Dateline. I think that there's a social context in which you have an obligation to understand. If you're going to put forensic evidence into the record, there's a certain obligation to understand the evidence you're putting into the record. And here we have a detective who is not even IAI certified to do friction ridge analysis testifying. I think that a prosecuting office has an obligation to investigate what their witnesses are going to testify to. I lost my train of thought a little bit in terms of responding to
You're
your
talking
question.
about what were the false statements, and you said it was that this was an objective methodology.
She has no error rate.
She has no error
She
rate.
said she has no error rate, and every fingerprint analysis, every pattern analysis has an error rate. This is misleading, not so much as false, but she pointed to the points of comparison between the two fingerprints to say, I have over 20 points of comparison, and that's how I know that I got it right. Oh, and by the way, I know I always get it right because my supervisor has never told me I got it wrong. And that's just not how science works, that there's confirmation and contextual bias pervasive throughout that entire statement. But Ms. Triplett, our expert, testified that the points of comparison are largely irrelevant to the quality of the match, and what is more relevant is the ambiguity in the points of comparison, which was not testified to at all. And I think when you're looking at this as a NAPU claim, you have a detective comes in and says, I am IA certified in crime scene analysis. The jury doesn't understand it. It has nothing to do with fingerprints. My supervisor tells me that I always get this right. I've never had a print comparison kickback. I am excellent at this. And there's just, what she testifies to is so out of sync with what the field says friction ridge analysis has to look like, that it misled. And we know it misled because of the centrality of the fingerprint evidence to the convictions versus the acquittals in this case. So I want to...
Counsel, if it misled the jury, isn't it also possible that it misled the prosecutor? And for a NAPU claim, don't we need the prosecutor to know that this testimony is false or misleading? Isn't that the centrality of the claim, that the prosecution has some reason to dispute the testimony and goes forward anyway? Why is that not missing here?
I think, so I recognize what, in 2020, the Department of Justice basically said you can't testify to any of the things that Detective Horning testified to. But I think if you look at the broader context, and that's what the documents in the post-conviction establish. If you look at the NIS report, if you look at the PCAST report, if you look at the APHIS report, if you look at all of this just enormous pile of authority that says that fingerprint evidence can't do what Detective Horning says it did.
We're putting this extra burden on, I mean, are you saying the because normally a lawyer goes to an expert and the expert educates the lawyer about that specific area, right?
Yes.
And so it's like you're putting an extra burden on the prosecution to, beside that expert, educate themselves separately.
And I think that with how routinely fingerprint evidence is used in criminal trials and is introduced by prosecutors, that is, to the extent that it is an extra burden, it's a very mild burden. And I would analogize it. I mean, I think that if you look at NAPU and Brady and Giglio all are part of the same general body of due process violations in criminal trials. And Kyles versus Whitney places a burden on the prosecutor to talk to police officers to get evidence from those officers.
Right.
So this is an analogous burden to the extent that it's a burden at all.
Okay.
Can you move on to the IAC claim and talk to us about why the decision not to cross-examine was strategically unreasonable in your perspective?
Yes, I think that the context here, there are a couple of things of the IAC that are kind of precursors to answer your question, but I will get to your question. Trial counsel started from the beginning and said, I'm operating from a deficit here. He did have a Daubert hearing. It was kind of by the seat of your pants Daubert hearing. He didn't even know that this evidence was going to be presented. So he's, in his words, starting from a deficit and trying to catch up. Does a little bit of research, identifies some of the documents that we put into the record, asks Detective Horning about those documents at the Daubert hearing. She doesn't know anything about these formative, kind of field-defining documents.
Well, counsel, isn't that overstating the record a little bit? I mean, she did express some familiarity with the NAS report in particular, but she didn't know the specifics of it. I mean, she'd heard of these documents. She just didn't know exactly what they said.
So to then some of the key things that the NAS report speaks to that contradict Detective Horning's testimony include objectivity versus subjectivity, the conversation about confirmation bias and context bias, which completely undercuts her point that I'm always right because my supervisor says I'm always right. Each of these would have been chapters of cross-examination that would have created a sinkhole underneath her testimony.
Can we play that out? Because if we have an expert witness that's saying, I've heard of these things, but I'm not exactly familiar with them, in the Daubert phase, if defense counsel were to then cross-examine on these treatises in front of the jury, and we get the same answer from the expert, like, I've heard of these, but I don't really exactly know what they say, defense counsel doesn't have their own experts, so they're not in a position to then introduce the treatises as like the leading, the leading source of information. They don't have anybody else to get up there and say, well, the state's expert is wrong. So they're left with answers that are like, I've heard of these things, but I don't know what they mean. How does that advance the defense case?
If I could demonstrate, I guess that I think the best answer is to demonstrate. Detective Horning, you testified that you are familiar with the NAS report identifying the culprit. Yes. You testified that you are aware that this is a document that is on the cutting edge of fingerprint and friction ridge analysis that has been done by scientists, not lawyers. Yes. I want to talk to you about confirmation bias, Detective. And then you go into not just the document itself, but the content of the document. So you testified that you know that you always got it right because your supervisor told you got it right.
But didn't defense counsel do that? I mean, defense counsel pushed back quite a bit on her testimony and the source of her conclusions and the basis for her conclusions, and actually got concessions on some of that.
But what you do then is you link it back to the foundational documents and you undercut her authority as an expert, and that's not what happened here.
Let me ask you one other question. In our direct appeal, or in Mr. Johnson's direct appeal, we're addressing the 16K issue. We said the evidence examination worksheet was not entered as an exhibit or otherwise placed in the record for us to evaluate. Was that placed in the record at any point in the post-conviction proceeding?
It was not.
Okay.
So to the extent that the 16K issue would have been an appellate issue, it wasn't constitutionalized in a way that would give relief under post-conviction. Okay. I think that if you look...
But it is just related to
Yes.
a lot of what you're arguing.
It is, certainly.
Yeah.
And I do want to go back to...
Well, you're at your time. I've kept you over, but do you have a question? Okay, sorry.
All right.
Are you okay?
If the court would indulge a response to the question of the fingerprint evidence and why we didn't hire our own experts, I can handle on rebuttal, or I can sit down.
If you can handle it in 30 seconds, that'd be great.
That overstates the burden of prejudice in both the Strickland claim and the NAPU claim. We have no need to prove innocence. We need to prove a reasonable probability of a different outcome. Attacking the testimony in a way that erodes the entire reliability of it is sufficient for a new trial, and the fingerprint analysis can be looked at in a new trial.
Thank you. Mr. Cummins, good morning.
Your Honors, I think to inform this whole discussion, I would encourage the court to review the defense's closing argument in the trial. If this court reviews the closing argument of the defense, it'll see that the defense's strategy in this case really wasn't about fingerprints and the reliability of the science at all. It was all about the circumstantial nature of the evidence, the circumstantial nature of how the fingerprints got on the bag. The defense conceded throughout oral argument that it's his fingerprints.
Well, how does that help? I mean, I think their position is that by attacking these exaggerated conclusions reached by the state's expert, that the reliability of the fingerprint evidence could have been undermined. I mean, I think they're saying that the defense should have pursued a different defense.
Well, I think that, I think it explains why the defense counsel declined to get a continuance to get a fingerprint expert. I think the defense understood that challenging the science of fingerprints was not going to be the necessarily most winning strategy for its
Well,
client.
that's not what defense counsel said at the post-conviction hearing. At the post-conviction hearing, he said that he felt that he could not accept the 1 to 2 day continuance that had been offered because that would not be meaningful, and that he needed a 5 to 6 week continuance in order to seek out his own expert, have the records reviewed, et cetera. And so the time that was put on the table by the trial court wouldn't have been sufficient.
That's correct. That's how he addressed it at the hearing. I still think it's very telling as to what the defense counsel did as he was handling the actual defense.
Well, because he was stuck with the fingerprint. He had to work with what he had.
He knew he was stuck. He knew that his client's fingerprints were found. It was a damning piece of evidence, and he attacked the circumstantial nature of it. Like, when was it put on the bag? We don't know. Did he know the drugs were in the bag when he touched the bag? I mean, that's the way Mr. Jackson attempted to attack, and that was more reasonable, really, in retrospect, than getting into a big semantical debate with the jury and the experts about the reliability of fingerprint science, which has been generally accepted for decades. The Supreme Court has said it's not even ineffective assistance of counsel to challenge fingerprint evidence anymore. I think when it's an attempt to rewrite history here, looking back and trying to make relevance and significance about the cockiness of a state's expert that said she never makes mistakes. She overstated
Well,
that.
but I
was
think
an
this
error,
all,
but-
I mean, it all ultimately goes back to the violation of 16K. Like, you guys didn't provide an expert report. And if you had provided the expert report, then we may not be in this situation. So, like, I feel like there's only so much that you can do to, like, push the burden off on the defense here.
Well, I think it's important to realize there is a burden on the defense in post-conviction. I mean, the NAPU claim, let's take the NAPU claim, for instance. That's going to have to require a showing of prosecutorial misconduct, which undermines the legitimacy of the whole proceeding. And here, we just don't have that. The prosecutor was not, bolstering false testimony. The prosecutor called this expert to testify to the fact that she identified the defendant's fingerprints. That was it. The debate that she gets into about whether or not it's subjective or objective, it's not about falsity. In fact, if you look at Ms. Triplett's testimony at the hearing, she says that the fingerprint science most of the time is an objective process. She says that on page 42. So even the defense's expert at the hearing agreed with the state's expert at trial and said most of the time, yeah, it is an objective thing. So this isn't about, putting forth false evidence and trying to get away with something and not correcting the record. This is obviously an internal debate in the science of fingerprint, analysis that the experts go back and forth on. Yeah, there's some subjective aspects to it. There's some objective aspects to it. But to characterize this as the prosecutor putting forth a false claim is just, it's incorrect, it's inaccurate, and it's unfortunate. And I think that the Supreme Court in Blanton did make clear that res judicata still applies in cases like this. It still applies where the issue could have been litigated at its earliest opportunity. All of these documents and treatises, they were available for the defense to make use of. To the extent this court couldn't review them on appeal is only because the defense didn't put them in at the trial. But it's not the fault.
Can you address whether it was strategically reasonable not to cross-examine Detective Horning with the treatises?
Yes. I think it was objectively reasonable for a couple of reasons. First of all, there's a few ways to skin a cat, as they say. The defense counsel had already been successful in front of the jury in getting the state's expert to admit that this was, in part, a subjective process. He made his point there, and to the extent he wanted to, use that further on closing argument, he could have done so. for him to have gotten into the weeds discussion about treatises and a bunch of studies with acronym names that nobody can remember or understand in the first place, even half the people in the science field itself, I don't think that the jury would necessarily follow that or be interested. He might have lost the jury, and I think he knew that wasn't his weakest argument anyway. His best play and the state's weakest point was the circumstantial nature of the case. And that's the way Mr. Jackson attacked it. If you read the closing argument, he makes no mention at all.
Mr. Combs, what about paragraph 26 of our prior decision where we remanded for the evidentiary hearing and we said, in light of trial counsel's attempts to challenge Detective Horning's testimony, we cannot think of a valid reason why counsel failed to confront Horning with reputable publications that contradicted or undermined her testimony or failed to request a jury instruction. Because this was such a critical piece of evidence that connected him to the drugs, there's a reasonable probability that but for counsel's deficient performance, the results of the trial may have been different. What do we do with that?
Well, I think that this court looks at the record as it now stands, and I think in light of everything the court now has before it, it's pretty clear that that was reasonable in the sense that the science is sound. The defense's expert really, in large part, agreed with the state's expert. Mr. Jackson attacked this case in the best way possible. For him not to have used all these treatises and these studies was a reasonable decision that I think is no difference.
What changed between our decision that Judge Bergeron just asked you about and now was an evidentiary hearing at which trial counsel testified about why he didn't cross-examine using the treatises. And he said it was because, quote, after hearing her answers where she knew absolutely none of them, no, they weren't presented at trial. So he seems to be offering an explanation that he didn't use these because the witness didn't know about them. Is that strategically reasonable, and if so, why?
Well, thank you. Yes, that's another very good point. I think that he realized that he wasn't going to get too far in a discussion with her about the nuances of these studies. I think he could have made a quite reasonable decision that he'll spend his energies elsewhere in a more productive pursuit, and I think that's what he did.
Well, but the reason for that is because the defense didn't have their own expert to come in and say, oh, this is the gold standard. Like, how could you not know about this, right?
Well, again, I would point to the fact that if it was this critical and he was that surprised, why would he decline a continuance? I understand he had an answer for that, but if truly he was going to make his stand on the reliability of fingerprint evidence, why wouldn't you demand a continuance to get your own expert?
So this was his trial strategy, which he did also testify about, that he was going to go ahead and accept the fingerprint as being his client's fingerprint and then make other arguments to deal with that.
Absolutely. And I think what else has changed since this court's past opinion is now you've got the testimony of the witnesses called at the post-conviction hearing. Their own expert didn't even review the evidence. I mean, if this court now had before it an expert who said, you know what, I looked at this evidence and this police lady got it wrong. She overstated this and she's wrong. Then we'd have something to talk about.
But you don't have to do that for a NAPU claim, right?
No, but it would certainly demonstrate prejudice, which has not been demonstrated on the record you have before you now. Basically, Ms. Triplett does nothing to further this claim. She herself equivocates and says, yeah, it's objective, it's subjective. She didn't review the evidence herself. So at the end of the day, Ms. Triplett's testimony does nothing to demonstrate their claim. Mr. Jackson, I think we do get some insight as to why he did what he did. And I think that he did do the best that he could. He did challenge the state's expert with these treatises, and he did mention the studies to her. And he realized that he wasn't going to get that far with this line, with this lady. And I don't think that was part of his overarching strategy in the first place. And I think that's clear when this court reads his closing argument. He was putting all of his efforts into showing how this was a weak circumstantial case. And I think that you know, in light of everything that the court has before it now, no prejudice has been demonstrated by any of these claims.
Well, are we bound by the language in the prior decision that the fingerprint was pivotal and that it was perhaps prejudicial to the case, given that there's an acquittal on the drugs in the house and there's only a conviction on the drugs in the car, and the real difference is that there's a fingerprint on this bag, which has another bag inside of it, which has the drugs inside of it? I mean, wasn't this fingerprint really crucial to the state's case?
Well, sure, absolutely. It was incredibly probative. That's why the state put that evidence on. Yes, I mean, it does link him to the crime that he was found guilty of, in addition to being seen coming in and out of the drug house and the furtive gesture that he has seen made, putting something or messing around with something between his legs down where that bag was ultimately found. Absolutely, it was prejudicial in that sense, but that doesn't mean it denied Mr. Johnson a fair trial. And I don't think anything has shown that the defense attorney here did anything but an admirable job with what he had. And ultimately, you know, to have attacked fingerprint science in front of the jury would be like tilting at windmills. It's been accepted, juries believe it, the Supreme Court says it's not even ineffective assistance not to challenge fingerprints. So he knew all that, and he knew that the best way to handle this case was the way he did it. And I think he did a fine job. Certainly, he did nothing that would undermine confidence that Mr. Johnson didn't get a fair shake from his counsel.
Are you saying the case law says that it's never an effective assistance not to challenge fingerprints?
The Supreme Court said just a failure to challenge fingerprint evidence is not ineffective assistance, yes, just because it is so well accepted.
Okay.
Now, I think that can be, you know, fleshed out here and there given a specific case, but overall, the general principle is very, very clear, and it sends the signal that, you know, defense attorneys are probably better left focusing their efforts on other aspects of the case, like maybe challenging the result itself or the circumstances of the placement of the fingerprint, which is what Mr. Jackson did, but not attacking the science.
Okay.
Unless the court has any further questions, the state would rest on its brief.
Great, thank you.
Thank you.
Mr. Clark, you have rebuttal?
A point of clarification. It may not be ineffective assistance to counsel to not file a Daubert hearing challenging the admissibility of fingerprint evidence, but to attack the weight of the evidence. The Supreme Court has never held that it's not ineffective to fail to attack the weight of the evidence. And that's because here, the science that we know about fingerprint evidence and the testimony that Detective Horning gave are simply not aligned.
But here's where I'm a little confused on your post-conviction ineffective assistance case, because the defense counsel testified that the best way to have countered Horning's testimony would have been to hire a competing expert.
Yes.
Why is the ineffective assistance claim not faulting defense counsel for demanding a continuance and hiring an expert?
Frankly, the ability to get in touch with defense counsel prior to filing the petition. I didn't file the petition, but I was counsel at parts of the hearing, didn't do the hearing itself. I'm here on appeal. Getting in touch and building that post-conviction record was a profoundly difficult process. So the last point I want to make is on prejudice, though. The trial court abuses discretion by saying that to grant post-conviction relief would be to not respect the jury's intelligence, because they're intelligent enough to suss all of this out themselves. And that misapprehends the nature of a Strickland claim or a NAPIU claim, because this case is about what the jury did not have in front of it to adequately weigh all the evidence.
To that point, to what extent are we bound or not by the language in the Johnson 2 appeal, characterizing this fingerprint as pivotal, as, you know, there being a reasonable probability that the trial would have been different if counsel had performed differently? Does this language merely inform our inquiry now, or does it bind our inquiry now?
I think it informs your inquiry, but I think it's very persuasive, especially in light of trial counsel's testimony that this was pivotal evidence that he did not have the opportunity to adequately confront. And
Has anything changed between the Johnson 2 decision and now in terms of the prejudice piece, or is all the evidence and information the same? Do you understand the nature of my question?
I do. The evidence is the same. And I think at Johnson 2 and today in front of you in this case, without crediting the fingerprint evidence, all we have is a weak constructive possession case.
But how is this not trial strategy? Instead of saying, this was not my client's fingerprint, or this might not be my client, or probably wasn't my client's fingerprint, he simply said, okay, even if it is, it doesn't matter, right? So isn't that just a strategy where he decided instead of attacking the fingerprint, he just accepted the fingerprint and built his defense within that?
He testified that the world of strategic possibilities he had were so limited by the circumstances of Detective Horning's case. He acknowledged, I think he had on cross-examination with the state an exchange about the various ways you could defend a fingerprint case, and he acknowledged that his trial defense was inadequate given that evidence.
But
So
if you had been able to go back to trial and you brought in your expert who testified at the post-conviction hearing, and she basically says kind of what she said, that like, well, this isn't, like, not 100% accurate, so forth and so on, but she's not offering a countervailing opinion that that's not his fingerprint. Like, how do you think the jury evaluates that at the end of the day?
I think that there's a couple of answers to that. The first is there's no post-conviction right to get the fingerprint evidence and do a comparison as you would with a post-conviction DNA statute. There's no right to post-conviction discovery. So the decision to put on a trial defense might look different than the post-conviction claim we did raise. And it might be that you would want to pad the testimony a little bit in ways that are not available in post-conviction, where there's, again, no discovery right, no right to testing of non-DNA forensic evidence. But what the jury could see from the evidence presented in post-conviction is that Detective Horning's testimony was so out of line with the field, and you would expect it to be out of line with the field because she acknowledged that she wasn't trained to the standards of the field. She's a crime scene investigator, not a friction ridge analyst. That they simply can't place weight in the conclusions that she drew. If I were to look at, I have an identical twin brother. I can tell my identical twin brother apart from me just looking at pictures because I see the distinctions. I don't think anyone here could, because you're not trained from your entire life in doing that. Similarly, if she is so out of touch with the practices of the field, we can't give any weight to her conclusion because it didn't come from practices, methodologies, and processes that the field recognizes as legitimate. It came from her own process, and that is not enough to credit a conviction.
All right, thank you very much for your argument. Thank you both today for your arguments. We appreciate it. The matter will be submitted. We'll get out a timely written decision.
All rise. The Court of Appeals for the Blood District of Ohio is now adjourned.
No sense.